Hey everyone, I hope you're doing well and staying safe during this time. If you're new here, welcome to the channel. Like I said, thank you so much for checking me out. If you haven't done so, please make sure to hit that subscribe button just right below the video. Cool, thank you so much. I really do appreciate it. And if you're returning, welcome back. Thanks again for your support. I truly do appreciate having you here.
But defendants Ripple Labs, Brad Garlinghouse, and Chris Larson seek an order sealing from public access certain documents submitted in connection with three pending motions. Larson's motion to dismiss, Garlinghouse's motion to dismiss, and the motion to strike Ripple's fourth affirmative defense, which is the fair notice defense. So these documents, you can see listed all here, and what is trying to be sealed. So the Larson sealing, the Ripple sealing motion, another Larson one, a Garlinghouse one, and then additionally, Ripple requests leave to file a SIR reply in connection with the SEC's motion to strike. The Ripple SIR reply is noted there with its number, and for the reasons stated below, there are some that are granted and some that are denied in part. So both granted in part, denied in part. Here's her rationale for this. Now again, this is Judge Torres, not Judge Netburn, who's talking here. So as far as sealing, the quote here from this case law is, "The common law right of public access to judicial documents is firmly rooted in our nation's history. This presumption of access is based on the need for federal courts to have a measure of accountability and for the public to have confidence in the administration of justice. Documents are considered judicial documents if they are relevant to the performance of the judicial function and useful in the judicial process. Moreover, the relevance of a specific document does not depend on which way the court ultimately rules or whether the document ultimately in fact influences the court's decision. Rather, what is important is whether a document would reasonably have the tendency to influence a district court's ruling on a motion. Furthermore, the presumption of public access is at its highest when the matter is relevant to a court's decision on a dispositive motion. After finding that documents are judicial documents to which the common law presumption of access attaches, courts must balance competing considerations against that presumption. The sealing of judicial documents may be justified only with specific, on the record filings that the sealing is necessary to preserve higher values and only if the sealing order is narrowly tailored to achieve that aim. Although the protection of sensitive, confidential, or proprietary business information is a countervailing interest that can militate in favor of sealing, conclusatory statements that documents contain confidential business information are insufficient to justify sealing. Rather, the moving party must make a particular and specific demonstration of fact showing that disclosure would result in an injury sufficiently serious to warrant protection. Moreover, the court shall not permit sealing of documents merely because information contained therein is subject to a stipulated protective order, because bargain for confidentiality does not overcome the presumption of access to judicial documents. So there's the background. Now here is what she's going to apply specifically to Larson's requests. Larson's requests that the court seal the memorandum of law submitted in support of his motion to dismiss the amended complaint, called the Larson memo here, his reply memorandum of law, the Larson reply, and the exhibits provided to him, exhibits A and B, which are legal memoranda provided to him in his capacity as Ripple CEO, should be filed under seal because, one, they have been designated as confidential by Ripple pursuant to stipulation and protective order entered by the court. They reflect the proprietary internal business strategies, analyses, impressions, and concerns of a private company and its founder on a range of sensitive topics that have never been made public to date. And that is the quote from Larson's motion there. Larson also contends that the references to the legal memos made in the Larson memo, Larson reply, and the SEC's memorandum of law in opposition of the motion should be redacted for the same reasons. In opposition to the SEC's motion to strike its fourth affirmative defense, Ripple seeks to seal the legal memos and requests that the court permit redactions of references to the legal memos in both the SEC's memorandum of law in support of the motion to strike and Ripple's opposition to the motion. Ripple argues that the legal memos should be sealed because they discuss aspects of Ripple's business planning that are non-public and completely sensitive, and they are not material to the case. Now here's the court's finding. The court holds that sealing of the legal memos and redaction of the associated briefing is unjustified. The legal memos and the briefing are unquestionably judicial documents because they were submitted to the court as, quote, supporting material in connection with two dispositive motions. The legal memos are relied on heavily in the amended complaint, that's the SEC complaint, and are discussed extensively in briefing on the motions to dismiss and the motion to strike. Indeed, Larson, Ripple, and the SEC urged the court to review the legal memos in full when considering the parties' respective positions. The court determines, therefore, that the legal memos and the associated briefing are judicial documents to which a high presumption of public access attaches because they are relevant to dispositive motions. Moreover, the court concludes that Larson and Ripple have not made a particular and specific factual demonstration of the harm that would result from disclosure, and even if disclosure of some of the information in the legal memos could injure Ripple's business interests, it does not justify sealing the legal memos in their entirety. Rather, it supports redacting those portions of the legal memos that relate to those potential harms and leaving in public view those portions relating to the relevant legal advice Ripple and Larson allegedly relied upon, which is discussed at length in the parties' briefing. Additionally, it is immaterial that the legal memos are subject to the parties' stipulated protective order because bargained for confidentiality does not overcome the presumption of access to judicial documents. The SEC has proposed specific redactions that address these concerns. Accordingly, the motions to seal the legal memos and associated briefing are denied. So, to summarize that, the court is just saying, hey, we don't care that this may have an impact on your business. It's relevant here, and as such, you are not allowed to seal it. And as such, with the redactions, you're not allowed to take out those portions from public view that you're asking because it's still relevant and you're citing from these documents, and so they need to be open for people to view. Now, here are the remainder of the request. So, Exhibit E and the associated briefing, Larson requests that the court seal a copy of an email attached as an exhibit in support of the SEC opposition, Exhibit E, and redact those portions of the SEC opposition that quote the email. Larson provides no justification for sealing Exhibit E and redacting the SEC opposition. Again, the court finds that Exhibit E and the SEC opposition are judicial documents because they are relevant to the court's ruling. Accordingly, the request is denied. Now you'll see here Exhibits K, L, and M, which are the Garlinghouse exhibits. He's requesting redactions to 3 exhibits filed in support of his own motion to dismiss. These exhibits consist of 2 Ripple internal communications and 1 between third parties discussing information obtained from Ripple. Garlinghouse explains that those exhibits reflect Ripple's proprietary internal business strategies, analyses, impressions, and concerns on a variety of sensitive topics that remain confidential, including, for example, Ripple's business relationships, product development, and legal and regulatory developments, risks, and requirements. He contends that they contain irrelevant and sensitive information concerning human resource and employee issues, and the identities of third-party customers and prospective investors. Garlinghouse cites K, L, and M exhibits in his reply memorandum of law to provide context for certain quotations and the amended complaint also refers to these documents. The court finds that K, L, and M are judicial documents for the reasons discussed above, but Garlinghouse sets forth specific facts justifying redaction. Proposed redactions protect any potentially sensitive information while leaving unobstructed the language relevant to the court's decision on his motion to dismiss. Accordingly, Garlinghouse's request to redact K, L, and M is granted. That's important because you can see here this was done in a more thorough manner with exact reasons given. And remember, Matthew Solomon is Garlinghouse's attorney, as we've seen in the various arguments, in the case documents and everything so far. He is more thorough and aggressive than the other attorneys, at least from what we've seen. And so you can see even further here that the fact that he is so thorough with everything goes to show that this was granted because all the ducks were in a row for Garlinghouse's request. Now, Part D of this, both Ripple and the SEC filed documents under seal in anticipation that the other party would request to seal them. These requests were not made. Accordingly, the court shall direct the clerk of the court to unseal those documents. Now, the SIR reply. Ripple requests leave to file a SIR reply in response to the SEC's reply memorandum of law in support of the SEC's motion to strike Ripple's fourth affirmative defense. Ripple argues that the SEC reply raised new arguments related to the court's ability to take judicial notice of information contained in a report produced by a private consulting firm. In its proposed SIR reply, Ripple argues that the court should not take judicial notice of this report and disputes the conclusions that the court should draw from this report if the court decides to the contrary. Motions for leave to file a SIR reply are subject to the sound discretion of the court. Courts grant leave to file SIR replies when they address arguments raised for the first time in a reply brief. Ripple has provided good cause for the court to grant its request to file a SIR reply because the SIR reply is directed to arguments The SEC raises for the first time in its reply accordingly. Ripple's motion for leave to file a reply is granted. Now again, pausing real quick before we go through the conclusion. That video again will be linked in the video description. Check that out if you want to see the full details on the reply. It's linked, it starts, all the chapters are in there, it starts right after the 2-minute mark. So do make sure to check that out for the full details, and the document itself will also be linked in the description. Now, in conclusion here, for the foregoing reasons, defendants' motions are granted in part and denied in part. So Ripple's or Larson's and Ripple's motions to seal were denied by February 17th, which is in about 2 weeks from today, the time you're seeing this. Larson and Ripple shall propose specific redactions that comply with the court's order. If they have not done so by that date, the court will direct the clerk to unseal and replace it with a redacted version, and unseal the legal memorandum and also replace it with the redacted version. Larson's motion to seal Exhibit E is denied by February 17th. He needs to submit a letter to the court explaining why it should be sealed, and if not done so by the date, then it will be unsealed. Larson's motion to file redacted versions of the memo, reply, and SEC opposition is also denied. He too has until February 17th to propose specific redactions there. Ripple's motion to file redacted versions of their opposition and the SEC motion also denied, but they have until February 17th to propose redactions. The Garlinghouse motions for exhibits K, L, and M were granted, and then the documents in the notes here that you can see in point 6 are to be unsealed. And then the reply motion is granted, so they have until February 9th to file that, so that's just under a week from today. And then finally, these last couple of motions are terminated. So this was again ordered today, February 3rd, 2022. You can see signed by Judge Torres, again, who's presiding over this case. So I hope you found this information to be helpful. We're seeing a lot more activity, decisions actually being made now, and Judge Torres stepping in and responding to these things that have been open items for some time now.
I'm your guy. I will keep you posted. I'm your advocate. I'll be back on a daily basis, usually multiple times per day, with these videos to keep you updated with everything going on. So I hope you enjoyed the video. If you haven't done so, make sure to hit that subscribe button. Feel free to share any of my videos with your friends, family, social media, or anybody who may care to listen. Thanks so much for your continued support. I'm always here for you. I want to help you through this time. So thank you so much for continuing to choose me. Enjoy your day, stay safe, and I'll catch you again probably in a couple hours. Thanks, everybody. See you later.